Good evening, everyone, and welcome to another episode of Common Sense. And tonight we are tackling a very important issue in the context of Guyana's national development, and that is the ongoing Guyana-Venezuela border controversy. And I want to encourage our viewers from the onset to share the live stream with your friends and with your families so that we can have as many Guyanese as possible watching so that our populace can be educated and informed about where Guyana is currently standing on this issue and what are the prospects for future developments. Of course, we're normally accustomed to financial literacy episodes on common sense, but because of the magnitude of this issue, I thought it best to take a break from the finance. I know money is very important, but at this point in our country's development, this issue can have serious effects on our development and our growth. So tonight with me, we have two very esteemed young men, two attorney at laws, Mr. Chevy Devonish and Mr. Rayon Miller, who will help us to delve deep into this Guyana-Venezuela border controversy and bring some amount of education and enlightenment to this very, very important issue. I want to ask our viewers to be very moderate and circumspect in your comments on the live stream. Please be respectful in everything that you say, because, of course, we want to be careful with our speech. It's a matter of international importance, and we want to be circumspect with the things that we say. So I want to encourage our viewers to be respectful and to be considerate in your speech. And you can ask questions. It's a live program. So I will be taking questions from the audience as we go along in our program. To begin our episode tonight, it's very important that we have an historical context of the Guyana-Venezuela border controversy, and then we'll work our way up to our current juncture in this issue. And we're going to invite Attorney at Law Rayon Miller to open up our discussion this evening by providing a brief historical context of the Guyana-Venezuela border controversy.
Hi, good night, Matthew. Thank you so much for having me. Let me start by saying definitely, yes, it could with you. But I will say that I am on this show in my capacity as a concerned citizen. And the views that I express here today are mine as a citizen. Now, a brief history. In 1498, the man we all know as the discoverer, Christopher Columbus, discovered what was to be known as the Guyanas on his third voyage to this part of the world. Now, as a consequence of this purported discovery, I mean, we all know that the indigenous people were occupying these lands at the time. But as a consequence of this purported discovery, the great nations of Spain and Portugal decided among themselves who would get one share. So the New World, or the Caribbean world, or the Guyanas as it is known today, was divided up between Spain and Portugal in a treaty that is known as the Treaty of Tordesillas. Now, pursuant to this treaty, Spain got a portion, Portugal got a portion. But the issue with just giving portions of land so vast in magnitude is that the parties really could not develop, occupy, and control the land because it was so big. So other nations at the time began to, go into those lands and occupy them. One such was the Dutch. The Dutch had actually set up an establishment in what would be known as Spain's land in Guyana, given to them under the treaty in 1595. That was by Captain Charles Lay. And the Dutch continued in this establishment of the settlement. And by virtue of this establishment, when the British took over from the Dutch, this establishment was given to the British in a treaty that's called the Treaty of London. And the British received all of the territory, and we became British Guyana. So that is a brief historical view of how the land came to switch hands from Spain, which is the colonizer of Venezuela, to Britain, which was the colonizer of Guyana at the time. In 1841, a popular man known as Robert Schomburg was commissioned to procure a map of the British Guyana and the border between Venezuela and Guyana as we know it, because at that time the border wasn't clearly set out because of how the parties came upon the land. And I think it was around 1841 the which categorically declared that the modified map submitted by Robert Schomburg would have been the border between Guyana and Venezuela, and thus came the border dispute between the parties.
All right, thank you very much, Mr. Miller, for that introductory historical background of the Guyana-Venezuela border controversy. Chevy, do you have any additional information to add to that historical context?
Thank you. First of all, thank you for having me. I'm happy to be here to contribute to this conversation. So, several years after the year that Rian made reference to, in the late 1800s, 1897 in particular, both Venezuela and British Guyana at the time, or the British government, because Guyana was still a colony at that time, they agreed that to resolve what was at that time a dispute, they would submit the issue to an arbitral tribunal. Arbitration is an alternative form of dispute resolution. It's an alternative to judicial proceedings, and it's a type of process that allow the parties to better come up with solutions that benefit them best, and perhaps more favorable resolutions that may come out of any judicial process which they may have submitted to. So they decided they would go to arbitration, and as part of arbitration, as part of the agreement to go to arbitration, one of the things that they decided that they would do is that they would accept the determination of the arbitral tribunal as final settlement of the border dispute. And note, I'm saying at that time it was a border dispute, and I like that everyone is using the term controversy, because that is what it actually is, and it has reference to a different subject that we're going to be talking about a bit later. In 1899, the tribunal, and the tribunal was a 5-person tribunal. It consisted of 2 persons from Great Britain, 2 arbitrators from the US, and 1 arbitrator from Russia. And each of the parties to the arbitration had arbitrators who they had a part in picking, as is usually the case in tribunals that have multiple arbitrators. So eventually, there was a decision in 1899, and the decision delineated the boundaries, the borders, and I wouldn't get into the details to say, for example, what run from where and across where, but what we now know as the map of Guyana, that boundary was determined based on, based on that arbitral tribunal, and it was accepted by Venezuela. And not only was it accepted by Venezuela, but Venezuela was happy. And this is a part that I don't see talked about much, but Venezuela was quite happy about the award, because part of the territory which they were awarded was considered to be very rich in various natural resources, including oil. So they were happy with it at that time. However, years later, in the 1900s, all of a sudden Venezuela decided, well, they didn't decide at that time, but one of the lawyers who took part in that arbitral tribunal on behalf of Venezuela, he was counsel for Venezuela. Upon his death, a memo was released, and in that memo, he alleged that there was some corruption which resulted in an unfair decision by the tribunal. And that has been the basis upon which Venezuela has continued to challenge the award in 1899. So, and that's why we say it's a controversy as opposed to a dispute, because the controversy surrounds Venezuela's claim that the 1899 award was marred in corruption and therefore is void. And that's why we use the term controversy now. Now, in, I think it was in 1966, before Guyana gained independence, and when Guyana was still a colony of Great Britain, a treaty was signed between Venezuela and Great Britain at the time. This was called the Treaty of Washington, and in that treaty there was an agreement that Guyana and Venezuela, this was the Geneva Agreement, my bad. The initial agreement was the Treaty of Washington. This is the agreement that they signed where they said that they would go to arbitration and would abide by the arbitral tribunal. So in the Geneva Agreement, they said we will take further steps to try to settle the controversy. And the machinery was the United Nations, and ultimately, more specifically, the good offices of the Secretary General of the United Nations. And this good offices process went on for several years. Now, shortly after the signing of the Geneva Agreement, Guyana gained independence. So Guyana was now participating on its own accord in these engagements, these good offices proceedings that were taking place. I'm going to skip ahead a lot on this part because the good offices process didn't yield much. There was not a decision or an outcome that was favorable to either party because Guyana maintained that the 1899 decision was accurate and it was a full and final determination of the issue. Venezuela continued to assert this claim, which, by the way, to this date, they have not adduced an iota of evidence to support, but they continue to claim that there was corruption in the decisions and that the award was null and void. So this process came to an end at the end of 2017, the good offices processes, after two Secretary Generals realized that we weren't getting anywhere. So it was the current Secretary General who referred the ongoing issue, the controversy, to the ICJ. He said that it does not seem as though the good offices process, and the good offices process is more like talks, mediation, conciliation, that type of thing. Talks to try to resolve the issue, but he saw that it was not working, and so he said that it seems as though the best step would be to refer the matter to the ICJ, which he did, and that is where we are now. Now, to talk a little bit about that, and I should say that there are certain legal rules which constrains us as attorneys in terms of what we say about the ongoing matter. It's a principle that basically dictates that you don't get too much into what is happening in court because there can be repercussions for that. You don't want to raise expectations. You don't want people to think that this is going to be a particular outcome and then it doesn't happen, and all sorts of issues can arise from that. But what I will say is that when the matter was referred and Guyana filed the matter before the ICJ, Venezuela at first challenged the jurisdiction of the ICJ and said that the ICJ had no jurisdiction to hear Guyana's claim, because Guyana was asking the ICJ to affirm, to first of all recognize the 1899 award as valid, not being void, as valid and as subsisting and as the correct indication of what the boundaries are and should be. That is one of the things Guyana was asking for. Venezuela said, well, ICJ, you have no jurisdiction to hear this matter. And all courts, including international courts, are required to first determine a question of whether it has jurisdiction to hear any matter. So the court said, all right, let's listen to what Venezuela is saying. Venezuela claims we have no jurisdiction to hear the question which Guyana has submitted to us, or these questions. And ultimately, they came down in Guyana's favor to say that they do have jurisdiction. And this is for several reasons, but the one I'm going to highlight is the fact that Venezuela signed the Geneva Agreement. In the Geneva Agreement, Venezuela agreed that the United Nations, including its Secretary General, had the authority and the power to determine how this issue is to be resolved. And this included, and would include, the ability to submit it to the ICJ. So for that and for other reasons, the ICJ said, well, we have jurisdiction and we will proceed to hear the matter. Venezuela appeared again and said, oh, wait, we have another issue. The Geneva Agreement was not signed between Venezuela and Guyana. It was signed between Venezuela and the British, because remember, at the time we were still a colony. And so they said that we don't have the proper parties before this tribunal, so these proceedings can't go on. So the court said again, all right, let's look at this. Is this the case? Now, it's indeed correct that Guyana was not a sovereign state when the Geneva Agreement was signed, but when you look at the Geneva Agreement and what the court recognized is that it was always Great Britain's intention that all of the activities and the processes that would follow the signing of the Geneva Agreement be handled by Guyana once it attained independence. So the ICJ again said, no, the proper parties are indeed before the court. Guyana, Venezuela.
All right, so we've just had a rich historical background of the Guyana-Venezuela border controversy, I noticed that you made a distinction between the word dispute and controversy. But I want to go just quickly back to when it was a dispute. In 1899, when the lines of demarcation were clearly awarded, were there any pieces of land that were awarded to Essequibo during that arbitration process?
You mean whether there were parts of the Essequibo that was awarded to Venezuela?
Correct.
No, there was no aspect of what we know now as Venezuela that were awarded to Venezuela. There's an issue with an island which is called Ankoko. This is not in Essequibo itself,
okay,
but there's an issue with that particular island in which there are claims to various portions of that island. Venezuela actually currently occupies Ankoko, and there have been skirmishes between Guyana and Venezuela as to which portion of the island belongs to whom, whether Venezuela should be occupying Guyana has actually asked the international community to intervene and to get Venezuela to stop occupying that portion of Ankoko. But as pertains to the Essequibo, which they are currently claiming, no part of that particular territory was given to Venezuela in the arbitral award of 1899. And again, the reason that I make a distinction between dispute and controversy is because it's a dispute if it's not yet settled, and there may be valid reasons why these claims are being made. That is, it's my own, it's your own. So if there are valid reasons and these reasons have not yet been determined, you can call it a dispute. But that dispute was submitted to arbitration and the dispute was resolved. So there is no longer a dispute as to the boundaries. There is a controversy, and I'm just repeating this, there's a controversy as pertains to Venezuela's claim that the award of 1899 is void because of some secret dealings that was claimed by this since deceased attorney, who asked that memo only be released upon his death, which is quite interesting.
And if I might add, Matthew, to what you have indicated earlier, it's even clearer that there is no dispute anymore, no controversy, when you consider the acts that Venezuela took immediately after the 1899 arbitral award. The establishment of boundary commissions, the acceptance of the boundary. I think even in their national currency, a coin was printed, a coin was made indicating the boundary that they accepted. And they didn't begin to protest until 1951, over 50 years after the arbitral award, when this controversial memorandum was published. Ironically, yet surreptitiously after the death of one of the attorneys on the arbitral proceedings.
All right, so I think it's very clear based on everything said thus far that Guyana has a very strong case, and that this controversy is clearly has ulterior motives and underlying motives for making it relevant once again in our time. Now, I want to examine the social and economic implications of Venezuela's current referendum and the potential effects it may have on Guyana. So my question to any of you, what are some of the social and economic implications of the current referendum?
Before we even get to the current referendum, I think it's very important that Guyanese know the questions that are being asked in the referendum. The first question is, do you agree to reject by all means in accordance with the law the line fraudulently imposed by the Paris Arbitration Award of 1899 that seeks to deprive us of Guyana Essequibo? Do you support the 1966 Geneva Agreement as the only valid legal instrument to reach a practical and satisfactory solution for Venezuela and Guyana regarding the controversy? Do you agree with Venezuela's historical position of not recognizing the jurisdiction of the International Court of Justice to resolve the territorial controversy? Do you agree to oppose by all means, in accordance with the laws, Guyana's claim to unilaterally dispose of a sea pending delimitation illegally and in violation of international law? Do you agree with the creation of Guyana Essequibo State and the development of an accelerated plan for the comprehensive care of the current and future population of that territory that includes, among others, the granting of citizenship and Venezuelan identity card in accordance with the Geneva Agreement and international law, consequently incorporating said state into the map of the Venezuelan territory? These questions are very interesting. Even when you look at the way they're posed, they're very interesting. Yeah, they're very interesting to read. They're very interesting to the persons that are going to vote. And it's very interesting to us as a territory of Guyana when you see the questions that the Venezuelan government are asking the people of Venezuela to decide.
If I can just add to that a little bit, the first one or two questions really is just asking, do you agree with our position? Do you reject the award, which is really inconsequential. I think it's the latter questions which are more important. And what's truly interesting is that when you examine Venezuela's conduct continuously throughout this controversy, when Venezuela wanted to act in relation to its claim, it has seized boats which have been conducting surveys in waters which it claims belongs to it. Happened when about the Technic Perdana was conducting some surveys. I think it was between 2012 and 2014. It has soldiers have several things have happened. Serious things have happened, and they didn't need so the question is, what is the effect of the referendum? Now they may say that, well, we have a mandate from the people to do that. But they really don't need a mandate from the people to do that. So then, the question is, what exactly is the efficacy, the purpose of the referendum? And you may say that, okay, it's a ratcheting up, it's an agitation of the situation because Venezuela has continuously and consistently ratcheted up their claims. A couple of years ago, so that the conversation touched and concerned the Essequibo, which is 2/3 of our territory. But what is attached to that is, and I'm getting a little into the economic implications of this. If you claim the land, you claim the seas that are adjacent to that territory. International law and Guyana's local legislation says that 2,000 nautical miles from the baseline of Guyana shores, and the baseline is the lowest watermark at the time of low tide. 200 nautical miles out, that is a country's exclusive economic zone, and our country has jurisdiction to exploit the natural resources in that area. So, and that is the area in which a lot of our oil blocks are found. So that is one of the economic implications of Venezuela's claim. If they're claiming the land, they're also claiming the seas and natural resources in those seas. But coming back to what I wanted to add to what Matthew was saying, it's, when you look at the questions have been asked, and when you look at the efficacy of the questions, and when you look at the purpose of the questions, they really did not need to do that. So there's a question of what exactly is the purpose of the referendum. But whatever the purpose of it, it's a very serious issue, and Guyana's it seems to have been taking it very seriously, to have submitted it to have been pursuing it before the ICJ, prosecuted before the ICJ, and hired very good legal representation to be able to do that. And I think you see that indication by the fact that we have successfully defended our position against two objections which Venezuela has made. So barring any other objection, we haven't seen any. Now what we're looking for whenever it comes is the final determination, and I think you said it, Guyana seems to have a very good case.
I want to emphasize that Essequibo is 2/3 of Guyana, and there is been some comments in certain quarters that Certain Guyanese have not really been taking this issue as serious as it ought to be taken. People don't recognize that Essequibo is literally more than 60% of Guyana. So whatever happens in Essequibo will have serious repercussions on persons living in Linden, Georgetown, and Burby. So it's not a case whereby Essequibo can be isolated and whatever happens over there stays over there. There are social implications in terms of persons moving, significant part of the economy when it comes to rice production and so forth. It's done in Essequibo, and as you mentioned, some of our oil blocks are in that region. So there is a potential for significant economic consequences that will affect not only persons in that region, but the length and breadth of Guyana. Now, the ICJ is set to rule tomorrow on the case. Venezuela, in their presentation at the International Court of Justice, has explicitly stated that regardless of the decision, the referendum will continue. Are there any sanctions or are there any legal recourse that the ICJ can take if Venezuela disregards its decision?
Right. So, as you mentioned, upon Venezuela's decision to hold this referendum, Guyana made an urgent application for interim remedies to stop some of the more problematic aspects of the referendum, some of the more problematic questions. Now, again, I don't like to make assumptions and I don't like to speculate. What I will say is that the decisions of the ICJ are legally binding. They're legally binding, which means that all parties to those proceedings are required and bound under international law to comply with the decisions of the court. So to speculate, let's say the ICJ says, Venezuela, you can't go ahead with these 3 questions. The ICJ does not have a very strong ability to force compliance with the decision. In a local court, let's say Rayon owes me money and he didn't pay, and I take him to, it was a contract, and I take him to court and I said that he breached the contract, he was supposed to pay me, he didn't, it's $5 million, I win. The court says I'm entitled to the money and Rayon has to pay me. 5 years has passed, let's say 1 year has passed, Rayon hasn't paid me. I can go back to the court and say I want to enforce the decision that you make, and there are various options open, and the mechanism of the state can be utilized to assist me. So we could probably take his car, or if he has 2 cars, take those, then start taking his jewelry, his clothes, this nice watch he's wearing in order to settle the debt. In international law, in the international arena, you don't have that particular mechanism. So there's no way to enforce the orders of the ICJ in that particular way. But you do have the mechanism of the United Nations, and there are various options which may be available, which it could include perhaps if it's submitted as a Security Council resolution for sanctions, perhaps something may be said by the General Assembly, but General Assembly decisions are not binding either. So what I mean to say is that there is no way to force Venezuela to stop. You can say stop, but Venezuela can say, I'm going to continue. But what we will have, if the court does say that, is a legally binding order by the court, which Guyana can utilize and wield in the international arena in support of its cause.
And I think that's definitely the route that is less problematic and is most likely appropriate, because when you look at the essence of all of the proceedings, the arbitral proceedings, the ICJ proceedings, it's really clear that the enforcement mechanism is in the party's good faith. When you submit yourself to arbitration as a state, even as a regular citizen, you say, hey, I'm coming to this forum, we want to settle this dispute. What are you going to do? What is the decision you're going to give in order for us to settle this dispute? The arbitration tribunal gave a decision. Venezuela said, no, we don't agree with this decision. And then they come now to the ICJ. Hey, we're going to submit to the ICJ. What is the resolution you're going to give for this dispute? And then they come again and say, it doesn't matter what you say in the ICJ, what a referendum says is what we're going to follow. So what then is left? It is a clear indication that the country has not been acting in good faith as a state entity. They've continuously been shifting the goalposts to their ultimate goal, which is to reclaim Venezuela by, I guess, all means.
Understood.
And Rian makes a fantastic point. The efficacy or the efficiency, the effectiveness of international law depends on the willingness of the parties in international law to comply with whatever determinations come out. After the 1899 decision, Venezuela turned back and said, this thing was corrupt, this thing is null and void. They agreed in the Geneva Agreement that we will follow whatever the UN says, and that included, what was implied in that is the possibility that it would be submitted to the ICJ, but then they turned around and said, we don't agree that the ICJ has jurisdiction. Then they tried to raise another issue, which is that all the proper parties are not before the court, so the matter can't go on. The court said all the parties are before the court, we will go on. So, seemingly having exhausted what the options which they perhaps consider to be in their arsenal, they have now decided to do something which they have complete control over, a referendum. People of Venezuela, tell us, do you want us to do these things? Right, which really has no international weight. And I mean, of course, you can't stop them from doing that, and they're doing that. But in terms of whether there's a legal basis for it, it doesn't seem that, well, there clearly isn't, and we continue to say that they have not provided any evidence aside from this letter, which is just a claim. It's like somebody come and tell somebody, and it's somebody who probably have good reputation. Hey, son, I hear that this man doing. It's kind of like high level gossip. So hey, son, this man, this thing I hear, this and so forth. Yeah, and then you believe it, and then you run with that. That is not how courts operate, and that is why the court.
And what is even more problematic, if I might add, Matthew, is the fact that we have a referendum that's being proposed by a regime. Now, this referendum is really all of the citizens in Venezuela, or those who choose to partake in the referendum, coming and voting on questions posed in the referendum on a way forward for the government of Venezuela to decide the issue. And when you look at that parallel compared to the parallel of the claims of Venezuela in terms of not keeping free and democratic elections, engage in elections rigging, I don't have to draw further conclusions for you to see how problematic that is.
Basically, the results of the referendum is a foregone conclusion.
And it's more clear when you look at the way the questions are framed. The questions are framed leading to an inevitable conclusion.
Definitely.
So here we are sitting deliberating on what you know is very likely to happen.
Definitely. Understood. Well, just in case you're now tuning in, we are discussing the Guyana-Venezuela border controversy, giving some historical insight and also presenting Guyana's current case. That is before the International Court of Justice. I also want to remind our viewers that this episode is sponsored by the Guyana Association of Bankers Incorporated. That is GABI, and you can follow them on Instagram and Facebook for more financial literacy tips. At this point in time in our conversation, as we prepare to wrap up, I'm going to ask a few opinionated questions. As citizens of Guyana, as both of you introduced yourselves as during the introductory remarks, and I'm going to start with Rion. Have you been satisfied with the response of the government of Guyana towards this entire Guyana-Venezuela border controversy?
You see, that is a tricky issue. Initially, what I noticed is that there could have been more public awareness. But definitely in the last few weeks, you've seen an increase in the public awareness from the government. And I mean, I went to the Ministry of Finance to collect a check. And when I collected the check, one of the tellers handed me a brochure stating, a public awareness brochure stating Guyana's case. And
how much was the check for?
Stating Guyana's case and giving awareness to the controversy that surrounds the border. with Venezuela. So definitely there is public awareness. I can't say the government seems to be doing the best that it can do in these circumstances. I don't believe they would be revealing any sort of military strategy to us as citizens of the Republic. But I mean, it's evident that the state actors at this juncture will have to put their best foot forward, because all of Guyana is depending on them to put their best foot forward, because that's all we can do in these circumstances.
Trevor, do you want to take a bite of that question?
Yeah, sure. So to address the question, and this is not an opinion, this is more of an examination of the reality. Let's look at what has been done. What we see is that the matter was submitted to the ICJ after it became evident that the good offices process did not work. And again, what we're looking here are effective measures to combat and to counter Venezuela's aggression. That action was taken, the matter was submitted. We have been, as I understand, filing our documents in time. Attempts by Venezuela to railroad the judicial process between at the ICJ have been continuously, successfully negated. There was a decision to, upon the hearing of this referendum, to make an application to the court to address this referendum. In terms of what can be done in relation to existing legal remedies, I think that what has been done is good, and we look forward to an outcome from that process. So I think that in terms of the options which would have been effective and which are available, we can talk about public education and yeah, public education is important, but public education and the issue will not resolve the issue. Yeah, more Guyanese are going to be more patriotic, perhaps, and that process is ongoing, I understand. And we can inform everyone that Venezuela is trying to get Guyana, so on and so forth. Venezuelan citizens are informed of the issue from the time they're in nursery school.
Definitely.
And it's continuous. You speak to most Venezuelans, they will tell you that the Essequibo belongs to them. But that has not stopped the process from moving to the ICJ, and that is not stopping the ICJ. So public education is important. But I think that what's more important to look at are the legal steps that have been taken, which are capable of producing a legally binding result.
Excellent. Now, the government of Guyana has repeatedly stated that they will not be engaging in any bilateral talks with Venezuela concerning this specific issue. The president is quoted as saying, if they want to discuss any other issues, he does not mind meeting the president of Venezuela. Do you think that this strategy of solely relying on the International Court of Justice is the best strategy, or do you think that we should open up some room or avenue for bilateral conversations on this issue?
Well, we that decision taken by the president has to be looked at in context. We have been talking for years, decades, and in terms of the good office process, we committed to talks for over 20 years. Guyana did not decide from the inception to go to the ICJ. They continued talks, and these talks went on and on. It was only when, after decades, it was realized that talks are not producing results, and the other side refuses to move, refuses to be reasonable. That is, so now we're before the courts because your obstinance has brought us here, and now we want to go back to having a conversation. It's like normal litigation. Let's bring it back to the local level, right? Rian owes me money. Which you can probably
insist on that.
That Ministry of Finance check that I collected the other day. Let's say Rian owes me money, and I've been trying to get my money from Rian for 2 years. But every time I call him, he doesn't answer the phone. Every time he sees me, he ducks. Every time I corner him, he telling me I gotta wait for that. and then I take him to court. And now that we're before the court, and things perhaps look a bit gloomy, now he's saying, hey, Chevy, sorry about that thing, man. Let me talk about this. Let me see how we're going to settle that. I think common sense and reason dictates that you don't make retrograde steps in this process. So it's completely understandable why the president would not want to go back to bilateral talks on this issue. It is before the court. The court will make a determination, and that determination will be in full and final settlement of the issue.
And definitely on the point of common sense. If you look at the track record as to where we are right now, you will see that any sort of bilateral talks will likely not give any fruitful event. Because look at it. The matter is before the court. Any sort of discussions or negotiations would tremendously undermine any decision that the court is going to give. And it is likely that the government of Guyana is going to heavily rely on the decision of the court. And then when we look back, let's take a step back. Look at the 1899 award, where both parties submitted themselves to arbitration. A decision was given. Venezuela reneged the decision. And then we signed a further agreement. Had talks in good faith, continued having talks in good faith. And all of this yielded what? So I don't think at this point the decision is best left to the court.
Definitely. And I want to echo the sentiments of our two attorneys. I think the part that the government of Guyana, successive governments have taken concerning having this issue resolved in the court after years of attempts of negotiation and bilateral talks is the best course of action. And of course, a favorable result in Guyana's favor will ultimately bolster its attempts to garner international support. And I know many Guyanese have been questioning the lack of support from the international community. Many persons have been stating, where is our allies and so forth. But I think the result tomorrow will significantly impact our ability to galvanize that international support that we do need if any eventualities of Venezuela acting on the results of the referendum.
Definitely. If any talk should be done at this point, it would definitely have to be with our allies.
Definitely. All right, so as we prepare to wrap up, are there any points that we may have missed tonight that the Guyanese people should be aware of as we await the decision of the International Court of Justice?
I think I've already talked too much.
Okay.
So I'm going to say no, but what I do want to encourage Guyanese to do is when that decision comes out, instead of relying on some other outlet to know what it says, I want to encourage every Guyanese who has the means to do so to get a copy of it and read it for themselves so that you have first-hand knowledge of exactly what it says. We may not know all of the details going way back to the 1800s, the 1700s and beyond. We may not know the details of the 1900s, but you can follow the developments coming out of the court and you can inform yourself from that. And I think every Guyanese who has the means to should.
Yeah, I would definitely agree with the sentiments of Mr. Sheffy. It's very important that Guyanese inform themselves on an outcome that will touch and concern all of us when the court gives it. So that would be my last point.
All right, so I think that we have done justice to the theme of the Guyana-Venezuela border controversy. Before we wrap up, I'm going to give you guys an opportunity, very briefly, within 1 minute, to offer some closing remarks to the Guyanese public.
I'll let Ryan have both of the 2 minutes. There's nothing additional that I'd like to add.
There's nothing additional I'd like to add, but I'd just like to reiterate that Essequibo is real.
Essequibo is real. That's right. Essequibo belongs to Guyana. And I have a few remarks that I just want to echo. I want to encourage our Guyanese brothers and sisters to be very responsible in the things that you post on social media, the things that you share. Ensure that whatever it is that you share or post is from a credible source. Rely on the official government agencies, that is the Office of the President, the DPI, NCN, and other reputable agencies for information. There will be a plethora of propaganda released over the next few days. There's going to be fear-mongering, but it's very important that you do not become riled up based on fake news, based on disinformation, and ensure that as you disseminate information as an individual, you're disseminating accurate, credible, and reliable information to your fellow Guyanese brothers and sisters. I think the government of Guyana is doing all that it can at this point in time in terms of awaiting the legal outcome of this matter. And after that, we continue to hope for good leadership and good stewardship of this entire controversy. And as we await December 3, we expect that good sense will prevail in this issue, and that hopefully our lives can return to some sense of normalcy within the very near future. I want to encourage persons, before you leave the live, to put some Guyana flags in the comment section so that people know that Esikobe is Wion. We're not budging on that stance. Esikobe is Wion. And as the famous song says, we're not giving up a blade of grass to anyone. So, our banks bear. So I want to encourage persons to be responsible, to be brothers keepers, and to ensure that whatever it is that you share or post comes from a credible and a relevant government agency. I want to thank our viewers for tuning in tonight. I want to encourage Guyanese to be unified at this point in time in a critical juncture of our national development. I think what happens over the next few weeks will have significant impact on the future of Guyana. So it's very important that we are strengthened by our unity. I think at this point in time, political bickering, folly, silly battles between political parties should be minimized, and the national goodwill should take precedence over anything else at this point in time. And we should try and emulate and bring to reality our motto, which says, one people, one nation, one destiny. So I want to encourage all of Guyana to be safe and to have a wonderful rest of the evening, and do await the outcome of the court case tomorrow at the International Court of Justice. Be blessed.
Right.